attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation of a Lawcast series discussing Rule 506 of Regulation D, including the difference between a traditional Rule 506B offering and a Rule 506C offering that allows for general solicitation and advertising. In prior Lawcasts in this series, I have talked about the fact that only accredited investors may invest in a Rule 506C offering, and that the company has an obligation to reasonably verify such accredited status. Today, I'm going to talk about the concept of reasonable verification of accredited status. Although the SEC has stated that a company can take any reasonable steps under the facts and circumstances, the SEC loves a facts and circumstances analysis, they have also included a non-exclusive list of acceptable steps in the rule itself, giving companies and practitioners a firm foundation for creating industry practices. In considering what is reasonable under the facts and circumstances, the company should consider: 1, the nature of the purchaser and the type of accredited investor they claim to be. So, for example, a well-known institution, broker-dealer, or bank would likely be accredited, and the company would not have to take much more reasonable steps to verify, if any. On the other hand, if it's just a natural person that is claiming to be accredited based on their net worth or their income, the company would have to continue with a much more in-depth review in order to verify their accredited status. Second, the amount and type of information that the company has about the potential investor. Clearly, more information is better. The SEC lists the obvious. You can have a W-2, tax returns, letters from a bank or broker-dealer. Although not required, it is assumed that the company would at least do a background check of publicly available information as well, such as just a Google check. Third, the nature and the terms of the offering. So, for example, if an offering is being conducted by solicitation to a pre-approved list of accredited investors from a trusted and reliable third-party source, the company will have to do much less to verify status. On the other hand, if it's an open-air solicitation via social media or television or radio advertising, then the company would have to do much more to verify accredited status. The more information a company has evidencing that a prospective purchaser is accredited, the fewer additional steps they have to take to verify that information, and vice versa. The less information, the more additional steps. Examples of the type of information that the company can review and rely on include: 1, publicly available information in filings with federal, state, and local regulatory bodies, such as Exchange Act reports and publicly available property records, including deeds and mortgages. 2, third-party evidentiary information, including pay stubs, tax returns, and W-2 forms that have been filed with the IRS. Or 3, third-party accredited investor verification service providers and other third-party sources. Now, this has become the industry standard. Most people rely on a third-party verification service, and many very respectable services have come to light in this industry. The SEC, in the rule itself, has also included 4 specific acceptable methods for verifying an individual's accredited status. That is, when an individual is claiming that they're accredited based on income or net worth. And those 4 specific acceptable standards or acceptable reviews include: 1, a review of copies of IRS forms, such as W-2s, K-1s, etc. 2, a review of bank statements, brokerage statements, and the like, together with a written representation regarding liabilities, because remember, it's net worth, so liabilities must be included. Or 3, a written confirmation from the person's broker, investment advisor, attorney, or CPA. This has also become an industry standard, by the way, in addition to a third-party verification source. And lastly, a written certification from an existing accredited investor that has previously invested in the company's prior 506 offering and any of those that are reviewed must be less than 3 months old. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.